Yeah, please, Your Lordship. I beg to mention item number 3 of on daily list. Your Lordship, the senior counsel is on leave, so we are praying for 2 weeks' time.
Please, Lordship, in this matter, I'm constrained to point out humbly that this is the 9th consecutive time that they are asking for time. 9th consecutive occasion, which means, my Lord, 9 times I've prepared for this matter, 9 times they've asked for time. They've adjourned the matter, my Lord. So if my Lord allows, my Lord.
Why?
It's a fairly simple matter. If my Lord allows, I can make my submissions today. 10th time for me to prepare, it becomes difficult, my Lord. I may be allowed to make my submissions. They can reply next week or whenever they
Do
want.
that.
Alright.
Okay.
Alright.
Please, Your Lordship. So, on the supplementary list, item number 2, Lordships had heard this matter yesterday relating to notional promotion.
Yes,
My Lord, now, I was going through this matter last evening. Now, there's an alternate prayer that my friend has introduced now with regard to the pensionary benefits, his terminal benefits. This I need some instruction. This is not a pleaded case by either party. This is a completely alternative prayer. I can't make any concession or any submission on this point without consulting the department. I've already spoken to them. We are to have a meeting in a day or two.
Oh, pensionary benefits comes with the, see, if the matter
Lordship.
is decided in his
Correct.
favor, then he is given notional promotion.
Yes.
So that, would have a, let's put it this way, a cascading effect as far as his pensionary benefits are concerned.
Just on that point, Manoj, because what we are saying is that we are confident, Manoj, that the case should be defeated on the point of delay. Number 2, even assuming Lordships are not persuaded on the point of delay and grant him any relief of notional promotion, he's not entitled to any kind of arrears of salary. Now, if he's not entitled to arrears of salary, consequentially, this is my understanding, he'll not be entitled to any restructuring in his pension. I just need some instructions from the department because this is not pleaded, my lord. There is no statement on the either in the petition or in my affidavit. I'm just seeking a week's time. I don't want to make any piecemeal arguments on this point, my lord. So I can argue the entire point next week, along with this issue.
Okay.
I've in fact conveyed this to my friend.
Is it required to be specifically prayed for?
Which is why I just need some instructions.
No, Lord, because when the petition was filed, the petitioner was still in service. Now that he has retired and we are only seeking for notional, so the relief will have to be molded, Lord, that's all. Specifically, there need not be any prayer, Lord.
Fine.
Just a week's time, my lord.
On premier by Mr. SN, Merit GA, appearing for the respondent, state respondent. Matter is adjourned. List is here after 1 week.
Lord, highly obliged.
Deep.
Supplementary list, item number 1.
May it please, Your Lordship. This is an application for bail. This case, my lord,
You are discussed? I think it's a bail matter.
Sorry. I came for the wrong list.
May please, Your Lordship. Lordship, the service is complete on the complainant, my lord. They come from a very poor background. I think legal aid should be.
What is the opinion of the IO? Where's the status report?
Lordship, let the matter come up at the end of the board, my lord.
You see, the IO has to file his compliance report. He has to give his opinion as to what would be the, let's put it this way, decision of the complainant, whether she would like to engage, firstly, whether she would like to contest the matter, number one. Number two, whether she would like to engage a counsel of her own. If not, number three, whether she would like, to apply for legal aid.
Lordship.
These are the options would be given to her or he, whatever. So then the matter becomes, complete.
Lordship.
But we need the IO's report for that.
My lord, with the permission of this honourable court, if the matter could come up tomorrow, Lordship. A bit,
Tomorrow will not be
there's a bit of
possible on my part.
difficulty, Lordship.
You have come
Because
from
Guwahati,
my lord, the IO is on maternity leave, my lord. So this matter had to be taken up by others, Lordship. That is the reason why service also was not complete at that on the last day, Lordship. So we're having some difficulty because she is the main person dealing with the matter, Lordship.
You see, there are two options for you.
my lord.
Either you can come personally, or you can appear by, through VC.
My
It's
lord.
up to you. You want to appear through VC? You can do so.
My lord.
Otherwise, unnecessarily for you to come all the way.
My lord, it's very difficult
Because-
the petitioner is also belong to my poor family, my lord.
Bail matters usually are not to be delayed.
My lord, I'm not speaking on behalf of the complainant, but Lordship, the complainant has come today and they come from a very, very, very poor background, Lordship. My lord, I've just interacted with them. They've
They've come.
come, Lordship.
That means the notice has been affected.
Yes,
Notice is complete, my lord. That was my first submission, Lordship. They're very poor and it appears, my lord, I don't know if I can submit on their behalf or not. It's best
No,
for
you see,
legally-
what you can do, since practically you'll be on the same side,
Lordship,
so you can talk to her
Lordship,
and explain to her that, as I've said earlier,
Lordship,
if she wants to engage, firstly, if she wants to contest the matter,
Lordship.
or alternatively, even if she comes
Lordship.
before the court, she cannot argue the matter.
No, Lordship,
It has to be conveyed through the PP.
Lordship.
Okay, that's number one. Explain that process to her.
If I may, my lord,
And then number two,
Lordship,
she can engage a legal aid counsel. And we have the legal aid High Court legal
yes.
Lordship,
Legal aid counsel.
legal service committee. That can be done through the secretary or whatever.
Lordship.
You can
So-
assist her in that manner.
My lord, I've spoken to the complainant, my lord, and they've expressed apprehension, my lord.
Okay. So
Lordship.
in that case, we'll fix the matter on Monday,
Tuesday, if possible, my lord.
Tuesday.
My lord.
We'll
So Tuesday, either you come personally or
I will come personally, my lord.
we'll try to get a status report, lordship, because it appears that because of the maternity leave of the IO, so we'll
Try to
try, my lord. Yes,
no, that has to be done. That
lordship.
has
But
to
the
be on record.
complainant has expressed much apprehension, my lord. Lordship.
Okay.
Then lordship, kindly fix it on Thursday, my lord, 4th September, my lord.
Okay. Mr. P.J. Sekil, Direct Counsel for the petitioner is present. Ms. N.G. Shila, Direct Senior GA, has once again sought for accommodation on behalf of the IO, who is yet to file the compliance report with regard to the notice with regard to the status of the notice issued upon the respondent / complainant. It is the prayer of the Learned CAG that this matter may be adjourned for the day to allow the said status report, compliance / status report to be filed within the next date fix. As
My
per-
lord, my friend has said, my lord, the complainant has received the, my lord,
No,
notice.
that will not go on record.
And further, my lord, the IO is on maternity leave, my lord.
No, but see, that will not go on record. That is, you see, that would be the initiative of the PP
My lord,
to talk to her, explain to her, whatever the case be,
my lord,
and eventually, on the next date fix, she will come.
my lord,
So, until she appears, officially, then we can note down.
my lord.
As of now, we cannot do that. And number two, that, as I said, that report has to come. So the records will be complete.
In
So
view of the,
we'll leave it at that. If at all, report does not come, but it should come.
my lord,
I'm not saying it should come. If at all
my lord,
it doesn't come, then the court will, will record the submission of the parties at the bar.
my lord.
My lord.
All right, lord.
Kunutungo? As agreed to by the parties, this is matter on 4.
Much obliged, lordship.
All right.
Daily list item number 1.
You're not filing, no? Can Respondent District Council is supposed to file affidavit, lordship. They have not done so till date.
Who is appearing?
District Council. GHDC. On the last order, they have informed the court.
Oh, because of the strike.
There's a ongoing strike there.
We'll give them a last chance.
Lordship.
None appears for the respondent 1 to 5. On perusal of this court's order dated 6/8/2025, it is noted that the Learned Counsel, Standing Counsel for the respondent 1 to 5 / JHDC has sought for accommodation to file, sought for time to file the said counter affidavit in opposition within the next date fix. However, in spite of such assurance, the affidavit in opposition has not yet been filed. Accordingly, this last chance is given to the said respondent to file the counter affidavit, failing which necessary orders shall be passed. This is matter to 3 weeks.
Item number 2.
Yes.
Please, Your Lordship. Lordship, the meeting was conducted on the last day, Lordship.
On the
I submitted
21st.
a copy, Lordship, before this honourable court.
My copy, please.
Sum and substance.
Lordship,
Did not.
see,
There was no settlement between
at
the
the last paragraph,
parties.
my lord, seeing no possibility of settlement, the negotiation stands terminated without any settlement between the parties, Lordship.
I don't have a copy of the report.
We met on the 21st of August, Your Lordship, and nothing materialized out of it.
So we'll continue with the
Yes, ma'am.
hearing.
I'm appearing on behalf of 5 and 6, Your Lordship.
5 6.
Respondent 5 and 6.
Who is 5 and 6?
MIDC and MEDCL.
That matter.
That matter, the corporation and the company.
Status 124, my lord. 123.
Actually, they are employees of the corporation and they are not entitled to anything, but they have been given a substantial amount, but they still insist on more, so, but it could not be settled.
The report is very clear, Lordship.
We'll hear the matter.
Hear the matter on merits.
Lordship.
Miss Yangi, Leonard AG, along with.
I am for this senior, not AAG, Your Lordship.
Oh,
not as AAG.
Leonard Senior Counsel, appearing for respondent 5 and 6. 5 and 6.
5 and 6, Your Lordship.
As well as Miss NG Sheila, Leonard Senior G, appearing for respondent 1, 2, 4. State respondent 1 to 4 has submitted that pursuant to the order of this court, allowing the parties to try and settle the matter amicably outside court. Several sittings have been conducted between the parties. However, eventually it is found out that there is no possibility or scope for any settlement of this matter or settlement of the matter between the parties. The related report has been filed for this court, which is brought on record and marked as Annexure X. Mr. K.C. Gautam, legal counsel for the petitioner, has submitted that under such circumstances, the matter may be posted for hearing on merits. How long? 2 weeks.
3 weeks, my lord.
Accordingly, as prayed for, list this matter up to 3 weeks for hearing.
Item number 3.
Yes.
My lord. My lord, what is before you is an appeal, my lord, against award of MACT Shillong. The background, my lord, is that the deceased in this case was walking on the road. A bolero came from behind and hit her. She succumbed to her injuries, my lord, on the same day. Now, that bolero, my lord, was insured with us. That bolero was owned by respondent number 2, driven by respondent number 3. Respondent number 1 today is the claimant. So claimant, my lord, filed the claim petition. Matter was processed. Finally, award was passed, my lord, awarding about 18,84,000 along with interest at 8%, my lord. We are not challenging the quantum. We are not challenging the quantum. What we are raising challenge against is the refusal of the learned MSCT to acknowledge, number one, acknowledge that the driver, that is respondent number 3, did not have any license. So this distinction is crucial, my lord. The distinction between a case where there is a fake license of the driver and a case where there is no license of the driver. This is one of those cases where driver had no license. So in other words, my lord, respondent number 2, the owner permitted a person without any license to drive the vehicle. Subsequently, accident occurred and the deceased succumbed to injuries, my lord. Now, I submit, and I'll back it up with the law, that when it is a case of no license, as opposed to a fake license, when it is a case of no license, the result is that the insurance company is released from any liability. The question of pay and recover also does not apply if it is a question of no license. If it is a question of fake license, then we are required to pay, and maybe the right is given to us to recover from the owner, my lord. But in a case of no license, the law states that we are released from liability, my lord. Now, as far as the fact that driver, respondent 3, did not have any license, I submit, my lord, that the evidence could not be clearer. Evidence of the IO may kindly be looked at page 33, my lord. Page 33 of the memo of appeal is the evidence of the IO. If I can direct Lordship's attention to the next page, 34.
Page 34.
It starts from 33, but relevant portion is at page 34. The second part of page 34 is the cross-examination. Somewhere in the middle of the cross-examination, my lord, when the driver had surrendered before Madanratting traffic branch. Somewhere in the middle, my lord, when the driver had surrendered. I'll read, my lord.
In the cross?
In the cross, my lord. About the 12th, 14th line, my lord. In the cross, when the driver had surrendered before the Madanratting traffic branch.
Okay, well,
my lord. I'll read this part. When the driver had surrendered before the Madanratting traffic branch, he did not produce any driving license. I have asked him whether he has any driving license or not. He has answered he did not possess any valid driving license. So the crystal clear evidence of the IO, who should be the best person to know, is that the driver did not possess any driving license.
Yes.
Number one. Number two, there was no rebuttal evidence from the side of respondent 3 or respondent 2 that yes, he did have a license. So this is unrebutted. This is crystal clear evidence leading only to one conclusion: driver, respondent 3, did not have any license. Now, what treatment did the MACT give to this evidence can be found at page 47 here, Lordship. How did the MACT appreciate this evidence?
Yes.
Page 47, para 61 of the judgment. I'll read, my lord. With regard to the driving license of OP number 2, it is found from the evidence of CW4 that when OP number 2 surrendered before Madanratting traffic branch, he did not produce any driving license. And when CW4 asked him whether he has any driving license or not, OP number 2 answered that he did not possess any driving license. Also, it is found that OP number 2 did not inform the owner of the vehicle when he drove the vehicle for washing. Now, OP number 3 contended that since the OP number 2 did not possess any valid driving license, hence OP number 3 is not liable to indemnify OP number 1 or make any payment to the claimant. Para 63, some Supreme Court judgment has been quoted, my lord. It has been extracted. If para 64, another judgment has been quoted, my lord. Para 65, my lord. Next page, that is page 49.
Yes.
Para 65 is where the finding of the MST is. Coming back to the instant case. Para 65, right at the bottom. Coming back to the instant case, this tribunal found that OP number 3 relied heavily on the evidence of CW4 that OP number 2 did not possess a valid driving license. But OP number 3, that is insurance company, on its own did not produce any evidence to show that OP number 1 ought to have verified that OP number 2 was having a valid driving license. Also, it is the burden of OP number 3, insurance company, to prove that there was a failure on the part of OP number 1 in carrying out due diligence to verify if OP number 2 was having a valid driving license before allowing OP number 2 to drive the vehicle. Para 67, my lord. In view of the above discussion, this tribunal found that OP number 3 is liable to pay compensation to claimant by indemnifying owner of Mahindra Bolero pickup number so and so. Lordship, I'll just pause, my lord. Para 65 contains the observation of the MACT that we are relying on the evidence of CW4 IO. But according to MACT, we have not produced any evidence of our own to show that the owner did not take due care, that the owner did not undertake due diligence to verify whether his driver had a valid license or not. Lordship, with respect to the MACT Shillong, this observation is a proper observation in a case of fake license, my lord. When a driver is engaged by me, I ask him whether he has a license. He shows me his license. I look at the license. It looks genuine to me. The Supreme Court, many judgments are very clear. It is not my duty to go to the DTOs and verify. As long as I have done the limited due diligence, that it looks genuine. That this observation will apply in a case of fake license, my lord. But in this case, owner has allowed a person without any license to drive the vehicle. In other words, when the owner engaged the driver, respondent 3, even the bare minimum that do you have a license or not was not conducted. We are not in a position to adduce evidence in that respect. It is something that is unprovable by us, but the circumstances show that the owner did not conduct the bare minimum necessary due diligence, my lord. He engaged a driver without any license, my lord. Number one. Number two, this observation at para 65 seems to suggest that the burden of proof is on us, my lord, to prove that there was no due diligence and the owner gave it to a driver without any license, etc. Burden of proof in MACT cases is not on the insurance company, my lord, as far as the license is concerned. Supreme Court in 2018 made this very clear. If Lordship kindly goes back to page 7 of the memo of appeal, page 7 of the memo of appeal.
Yes.
I've extracted a judgment. I will, of course, give copies along with my written synopsis. This is, my lord, Pappu versus Vinod Kumar Lamba. This 2018 3 SCC. Para 8, my lord, Roman 8. I've extracted page 7 of the memo of appeal.
Page 7.
7, my lord. Memo of appeal, my lord.
Page 7
of the memo of appeal.
That's, I think it starts from page 6. Eh?
Oh.
Para, Roman 7.
My lord. Page 7, para 8, my lord. Para Roman 8.
Not here. It's, see, here 7 starts 12 and 13. Paragraph 12 and 13 of.
My lord, that is the extracted portion. Exactly. Extracted judgment. Just above that, Lordship will find para 8, Roman 8 is there.
There's no Roman 8.
Sorry, para Roman 7. Para Roman 7. Sorry. Sorry.
That's what I was telling you.
Completely my mistake, my lord. Completely my mistake.
That is at page 6.
My lord.
Then you come to. Yes.
So, my lord, there is a judgment referred, Pappu versus Vinod Kumar Lamba, 2018, 3 SCC 208.
You have referred to
Pappu versus Vinod Kumar Lamba.
Yes.
2018, 3 SCC 208.
Yes, please.
My lord. So I'll just read para 12 and 13, my lord, from this judgment. This court in National Insurance Company versus Swaran Singh has noticed the defenses available to the insurance company under section 149(2)(a)(2) of the MV Act 1988. The insurance company is entitled to take a defense that the offending vehicle was driven by a unauthorized person, or the person driving the vehicle did not have a valid driving license. The onus would shift on the insurance company only after the owner of the offending vehicle pleads and proves the basic facts within his knowledge that the driver of the offending vehicle was authorized by him to drive the vehicle and was having a valid driving license at the relevant time. So the onus is first on the owner to prove, plead and prove. Only then the onus shifts on us. Para 13 makes that clearer. The next paragraph, my lord, I'll just read the underlined portion, my lord. Respondent 1, owner of the offending vehicle, did not produce any evidence except a driving license of one Joginder Singh without any specific stand taken in the pleadings or in the evidence that the same Joginder Singh was in fact authorized to drive the vehicle in question at the relevant time. Only then would onus shift, requiring respondent number 2, insurance company, to rebut such evidence and to produce other evidence to substantiate its defense. This is important, my lord. Merely producing a valid insurance certificate in respect of the offending truck was not enough for respondent 1 to make the insurance company liable to discharge his liability arising from rash and negligent driving by the driver of his vehicle. The insurance company can be fastened with the liability on the basis of a valid insurance policy only after the basic facts are pleaded and established by the owner of the offending vehicle that the vehicle was not only duly insured but also that it was driven by an authorized person having a valid driving license. Without disclosing the name of the driver in the written statement or producing any evidence to substantiate the fact that the copy of the driving license produced in support was of a person who in fact was authorized to drive the offending vehicle at the relevant time, the owner of the vehicle cannot be said to have extricated himself from his liability. The insurance company would become liable only after such foundational facts are pleaded and proved by the owner of the offending vehicle. So, my lord, very clearly, could not be clearer, my lord, in fact, our liability will arise only once the owner has adduced evidence. Only once the owner pleads and adduces evidence that he gave the vehicle to a person who he thought at least held a valid driving license. In this case, no such evidence is there. So the question of MECT holding us responsible to adduce evidence is with respect not correct, because first the owner has to adduce evidence. No such evidence has come on record, my lord. Now the consequence of this situation where a person has driven a vehicle without any license whatsoever, leave aside a fake license, the consequence is that unlike a fake license case where we are asked to pay and then recover from the owner, the consequence in such a case of no license is that we are released from liability. The liability would fall squarely on the owner or the driver jointly and severally. This, my lord, is clear from from para 8, Roman 8. I believe that would be at page 9 of the memo of appeal.
Page
9.
8.
Para Roman 8.
Roman 8.
Page 9 of the
8 or 9? It starts from 8.
My lord, my copy is 9, my lord.
What is your copy? I mean,
there could be a mismatch, my lord. Page 9, Roman 8. Para Roman 8, that is.
Here, in fact, page 8 is very bold.
Para 8, if lordship looks at, my lord. Para 8, Roman 8. Whichever page.
Roman 8, let's go for that, but then
my lord,
it's at page 8 here.
My lord, para 8, para 8, Roman 8. I have referred to a judgment, Supreme Court, the famous judgment of Swaran Singh, National Insurance Company versus Swaran Singh, AIR 2004, SC 1531. I'll just read the extracted portion, my lord. Swaran Singh, AIR, National Insurance versus Swaran Singh, AIR 2004, SC 1531.
Okay.
Para Roman 8, my lord. I'll read the extracted portion, my lord. We have analyzed the relevant provisions of the said act in terms whereof a motor vehicle.
Which para?
Roman 8 of the Memo of Appeal.
No, I mean the Swaran Singh. You have extracted from which file?
I'm sorry, the para number is not mentioned. I'll mention it in my written argument, my lord. But this is directly from the judgment, my lord. I missed out the para number, my lord. I'm allowed to read this extract. We have analyzed the relevant provisions of the said Act in terms whereof a motor vehicle must be driven by a person having a driving license. The owner of a motor vehicle, in terms of Section 5 of the Act, has a responsibility to see that no vehicle is driven except by a person who does not satisfy the provisions of Sections 3 or 4 of the Act. In a case, therefore, where a driver of the vehicle admittedly did not hold any license and the same was allowed consciously to be driven by the owner of the vehicle by such person, the insurer is entitled to succeed in its defense and avoid liability. So in a case of no license, where the vehicle has been given by the owner to some person without a license, then insurer is entitled to succeed in its defense and avoid liability. So we are to be released from liability in such a case. Supreme Court has reiterated this position of law in yet another judgment, my lord. This is in the next paragraph, my lord. Roman 9, that is.
Yes.
United India Insurance Company Limited versus Gyanchand, 1997, 7 SCC 558.
Yes.
This is at para 10 of this judgment, my lord. United India versus Gyanchand. I'll read extract, my lord. We fail to appreciate how the aforesaid decision can be of any avail to learned counsel for the respondent claimants on the peculiar facts of the present case. It has been clearly held by the tribunal as well as by the High Court that respondent 1, who was permitted to drive the vehicle by respondent 9, the insured, was admittedly not having any driving license. It was not the case of respondent 9, the insured, that he did not know that respondent 1, whom the vehicle was being handed over, was not having a valid license. In fact, once he did not step in the witness box to prove his case, an adverse inference has necessarily to be drawn against him to the effect that the vehicle had been handed over by him for being driven by an unlicensed driver, respondent 1. That finding reached by the tribunal as well as by the High Court must result in exonerating the insurance company of its obligation as the statutory defense becomes available to it. I'll just stop here, my lord. So in a case of no license, the result is that it results in exonerating, that means releasing, my lord, the insurance company of its obligation, my lord. So there is no question of pay and recover that is applied. Next paragraph, my lord, again from the same judgment, para 12, that is, under the circumstances when the insured had handed over the vehicle for being driven by an unlicensed driver, the insurance company would get exonerated from its liability to meet the claims of the third party who might have suffered on account of vehicular accident caused by such unlicensed driver. So, my lord, this is one of those cases where pay and recover will not apply, my lord. Pay and recover will not apply. We are to be released from any liability in the matter. If there is liability to be affixed, liability has to be affixed on the owner, my lord. It has to be affixed on the owner. This is one part of my submission. The other part, a parallel part, is that worst case, even if lordship, out of the goodness of lordship's heart, holds that it may be difficult to recover 18 lakhs odd from the owner, and lordship gives us the right to pay and recover, even that would be some solace to us, my lord. It will be some solace to us. Though, frankly, I have to say this, I have to submit this, it would be against the law set out by the Supreme Court, my lord. But here what has happened, MACT has refused to give us that right to pay and recover also. So that is another aspect, another point on which we are challenging the award of the MACT. The fact that...
Is the owner appearing?
Owner is appearing. My friend is appearing. Owner is appearing.
You are the owner.
So this is in respect of the driving license, my lord. And this, as I said, is the primary challenge that we are raising. Now, we are not on the quantum, we are not touching anything on the quantum, etc.
That would be of no consequence to you, of course.
My lord, if we are released from liability, there is no point in wasting time of this honorable court on that point, my lord. But just one additional aspect remains. In this case, what had happened was initially, during the start of the case, we had paid interim relief, IR of 50,000, my lord. That IR, my lord, if Lordship looks at page 54, if Lordship looks at page 54,
Yes.
this is the forwarding letter to the learned MSCT. This was on 26th July 2019. So we had given a check was deposited, check has been encashed, my lord.
Yeah.
That 50,000 adjustment has not been done in the award, my lord. So in any event of the matter, even if we had to be released from any liability, this adjustment may be necessary. And secondly, if we are not to be released completely and pay and recover is to be imposed on us, even then, my lord, the 50,000 will be required to be adjusted, my lord. So, my lord, this is the end of my submissions. It's a very simple matter that we have placed before this honorable court. It is a matter where, unlike a case of fake driving license, my lord, it's a case of no driving license, which is different from fake license, my lord. Fake license, pay and recovery, knowledge of owner, whether he knew, did not know, all that comes in. In a case of no license, where very clearly owner has given the vehicle to a person without any license, we have no liability in the matter. If liability is to be fixed, it has to be fixed on the owner, my lord. That's all.
My lord, I am for the claimant, respondent number one.
You are for?
Respondent number one, claimant.
You have not made any counterclaim?
No, my lord, I have not.
No cross
because
appeal?
no enhancement, nothing, not required.
Then?
So, my lord, only.
Say? Nothing?
No, my submission is that, my lord, that the insurance company.
Okay. That Sir Blue 4 is your witness.
Yes, my lord. Because their submission is that, my lord, that they are not liable to pay because there was no valid license or no license. My lord, the honorable tribunal has already relied on the judgment which is in page number 49, your lordship, which my senior has also read. Page 49.
Page
49. Learned tribunal has also relied on the judgment passed by this honorable court, and that judgment was passed taking into consideration.
Just a moment. Para?
Well, page 49, para 64.
64.
Yes, my lord. My lord, the learned tribunal has relied upon the judgment of this honorable court, which was passed, my lord, based on the judgment passed in Swaran Singh.
Yes.
So, my lord, here paragraph number 7, 64, the observation of the honorable Supreme Court, my lord.
Yes.
Mere absence, fake or invalid driving license or disqualification of the driver. 4 circumstances has been cited, my lord. Mere absence, that means no license, then fake, and then invalid. Invalid when the license is over, the validity is over. So all the 4 circumstances has been mentioned here.
Yes.
So, my lord, this is the judgment, my lord. So therefore, my lord, the submission, the contention of the insurance company that this is a different case from fake license and no license, it will make no difference, my lord, because the consequences will be same. The insurance company is required to pay the compensation on the policy, under the policy issued, and then to recover the same from the owner of the vehicle. This is the law, my lord, settled principle of law. So all the circumstances has been cited, and the tribunal has taken care of that, my lord. Now, my lord, again 48, page number 48.
48?
Yes, my lord.
Yes.
Again, the learned tribunal has relied on the judgment, my lord, of the Honorable Supreme Court. The last bottom 3 lines, my lord.
Para?
Bottom 3 line, my lord. As
This
such,
para 63?
in the same 63, para 15, and thereafter.
No, 48, page 48.
48, last 3 lines, my lord.
True, but it is Oh, this is in 62 itself. Huh?
Yes, my lord. 62 is the this one, and then 63 is the judgment.
Yes.
Then again, paragraph number 3 and 15. The last paragraph.
15.
Yes, my lord.
As already.
As no such exercise. In the last 3 bottom line, my lord. As no such exercise was undertaken.
Okay.
Undertaken, the petitioner insurance company would have no right to recover the compensation amount from the present owner of the vehicle. Of course, this submission will be made by the driver or the owner, my lord. However, just because it will also affect my right, my lord, to get the compensation at the earlier. So the insurance company was also under duty bound, my lord, to prove that the owner has not taken care while engaging the driver. This is also the bounden duty of the insurance company before the tribunal. They have not taken any care of that. In fact, they have crossed also, my lord, which has been read out by my learned senior, that in the cross examination the IO has said that he was not having valid driving license. He has not said that he was not having license at all. So that is still under doubt, which has not been clarified even by the insurance company by effective cross examination. So that is, leave it apart, my lord. The thing is that the Honorable Supreme Court has time and again has said that the claimant should not suffer, because the insurance company has to pay under the policy and then to recover from the owner by following the due process of law. Only my learned senior is aggrieved because the learned tribunal has not observed in the judgment that to pay and recover, and that 50,000 has not been. That can be modified to that extent only, my lord, and then I should not suffer, my lord, because I have nothing to do whether insurance company or pay or this, because I am entitled. So, my lord, I am relying on the same judgment, my lord, which has been referred here, and with regard to another judgment, my lord, that is 2001-4 SCC.
2004
SCC. Just give my lord.
Yes.
In the last paragraph, my lord, paragraph number
Para
20, my lord, 19, 20, 21 and 22 and 23 are very relevant, my lord, because the section has been quoted 149 of the MSCT Act, and then paragraph number 20 said, my lord, very clearly, paragraph number 21, a reading of the proviso to subsection 4 as well as the language employed in subsection 5 would indicate that they are intended to safeguard the interests of an insurer who otherwise has no liability to pay any amount to the insured but for the provision contained in chapter 11 of the Act. This means the insurer, that is the insurance company, has to pay to the third party, that is to the claimant, only on account of the fact that a policy of the insurance has been issued in respect of the vehicle, but the insurer is entitled to recover any such sum from the insured if the insurer were not otherwise liable to pay such sum to the insured by virtue of the condition of the contract of the insurance indicated by the policy. So the contention that even if their driving license was not there, there is no, they can recover it from the company. And then my lord, 22, to repeat, the effect of the above provision is this: when a valid insurance policy has been issued in respect of vehicle as evidenced by certificate of insurance, the burden is on the insurer to pay to the third party whether or not there has been any breach or violation of the policy condition, but the amount so paid by the insurer to the third party can be allowed to be recovered from the insured if, as per the policy condition of the insurer, had no liability to pay such sum to the insured. So my lord, and then paragraph 23 also says like that only. So my lord, this is the covered case, my lord, that they have to pay and then they have to recover. So this is my submission with regard to this. So far the interest contention has been not raised, my lord. I'll just not make any submission.
So
May I please, Your Honor? I am appearing on behalf of the respondent number 3, the driver.
Yes.
Your Lordship, I will like to respectfully submit that the learned member of the tribunal was absolutely right in awarding compensation in the present appeal, Your Lordship. Your Lordship, in the present appeal, the appellant was stressing on the fact that the driver was having no valid driving license at the time of the incident. But then, Your Lordship, there are Supreme Court judgments where it has been stated clearly, Your Lordship, that the mere non-production of license or assumption made by the IO, because here in this case, Your Lordship, the only evidence is the evidence of the IO, in which in its cross at page. Page 32, there's no page number. There's no page number in my copy, Your Lordship. See the cross-examination of the IO, Your Lordship. Is it page 33? Page 33, Your Lordship.
30. Again, it's page 34 here.
It's because there's no page number in my service copy.
Relevant page 34, my lord.
Should have been more diligent.
We seem to have slipped up in this matter, my lord. I sincerely apologize for that.
Okay. We'll take it at page 34. Yes. There, that's where the cross of the IO is.
The IO, Your Lordship, yeah. Yes, Your Lordship. Where he has clearly stated that when the driver has surrendered before the monitoring traffic branch and he did not produce any driving license, and I have asked him whether he has any driving license or not, he has answered he did not possess any driving license. Your Lordship, I would like to state that this is just evidence of the IO, Your Lordship, and then the appellant in this present case has not crossed the driver. There was no cross of the driver, and then just evidence of the Your Lordship is not sufficient to amount.
This was cross-examination by who
of
was
the
OP,
IO.
Who was OP3?
We are OP3.
You're OP. This is the cross-examination by them.
Yes, Your Lordship. Of the but the driver, Your Lordship, was never crossed in this at the trial stage, and then Your Lordship.
Whether, see the driver, whether he has produced himself as a witness, or whether he was listed as a witness by either of the parties, is there?
No, Your Lordship. So, Your Lordship, I would like to submit like that is just the evidence of the IO, Your Lordship, and the insurance company must produce the record from the transport authority or examine the driver, which was not done in this present case, Your Lordship. Your Lordship, I would like to rely my submission on this on one Supreme Court judgment, Your Lordship, Rukmani and others versus New India Assurance and others. It's 1998, volume number 9, Supreme Court cases, page 160.
1998, 9.
Yes, Your Lordship.
160.
Page 160, Your Lordship.
Para? Oh, there are only 3 paragraphs. Yes.
The reading of this of this case, Your Lordship, clearly stated that it is the duty of the the reading of para 3, Your Lordship, we have seen the only evidence of the insurance company produced in support of the plea. This is the evidence of the inspector of police who investigated the accident. In his evidence, PW1, who was an inspector of police, stated in his examination in chief, my inquiry revealed that the first respondent did not produce the license to drive the above scooter. The first respondent, even after my demand, did not submit the license since he was not having it. In his cross-examination, he has said that it is the inspector of motor vehicle who is required to check whether the license is there, but he has not informed the inspector of vehicles that the first respondent was not having a license. He thought it was not necessary. In view of in our view, this evidence is not sufficient to discharge the burden which was cast upon the insurance company. It did not summon the driver of the vehicle. No records from the Road Transport Authority was also been produced. In these circumstances, the insurance company has not discharged the burden cast upon Section 96, subsection 2, clause B, subclause 2 of the MV Act 1939. The impute order of the High Court is therefore set aside and the order of the tribunal is restored. Your Lordship, like the reading of Section 139, which is in the old Act, and then Section 92 of the old Act, and Section 149, which of the new Act, Your Lordship, it's the same, Your Lordship. And even the Learned Tribunal in its judgment at para 69, Your Lordship, page number 14 of the copy of the judgment. Page 14 of the...
Yes, para 69.
Yes, Your Lordship. I'll read I'll extract the reading, Your Lordship. The insurance company, OP3, did not adduce any evidence to prove the statutory violation of any condition contained under Section 149, subsection 2 of the MV Act, and hence the OP insurance company is liable to pay the entire amount of compensation to be awarded by this court. The insurance may take a plea that the driver was not having any license at the time of the accident, and as such, the insurance is not liable to pay the compensation. The owner and the driver was never examined as the witness by the insurance company in order to avoid its liability by the insurance company. It is not sufficient to show that the person driving at the time of the accident was not duly licensed. The insurance company must establish that the breach was on the part of the insured. So, yes. It is humbly submit, Your Lordship, that the reading of the judgment by the Learned Tribunal and the Supreme Court judgment in the Rukmini New India Assurance, Your Lordship, it doesn't make the insurance company make them escape their liability to pay the compensation, Your Lordship.
Owner, next date.
Lordship, can I respond to these submissions?
Let the owner come.
Lordship, the submissions may skip Lordship's memory, so my responses may not make sense on the next day. If Lordship allows.
Otherwise, I have my notes with me.
I'll just take 2 minutes, my Lord, if Lordship allows. My Lord, first I'll respond to the claimant's submission.
Yes.
Claimant, my Lord, has exclusively relied on the judgments, the 2 judgments relied on by MACT. That is at page 48 and page 49.
Yes.
First, I'll deal with page 49 judgment, which is the judgment of this Honorable High Court itself in Oriental Insurance versus Yorlinda Talang. My friend, for the claimant, for respondent 1, has relied on para 7. Page 49, my Lord. At para 64 of the judgment.
Yes.
Of the MST judgment. So this is the Yorlinda Talang judgment. My friend has relied on para 7 of this judgment.
Yes.
Now, if I'm allowed to read para 7 slowly, my Lord. Mere absence, fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third parties. To avoid its liability towards the insured, the insurer has to prove that the insured was guilty of negligence. This is one part, my lord, and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of vehicles by a duly licensed driver or one who was not disqualified to drive at the relevant time. So, my lord, what this judgment of this Honorable High Court has said is that merely because there is an absence of license or fake license or invalid license, that is by itself not enough. There has to be proof of negligence of the owner. We have to prove that owner was negligent or failed to exercise reasonable care. Now, my lord, here I rely on a very simple proposition, a very simple maxim of law, res ipsa loquitur, my lord. Facts speak for themselves, my lord. The fact that the driver of the vehicle at the relevant time did not have a driving license, and the IO's evidence in this respect is very important. My friend for the claimant had faintly suggested IO had said he did not have a valid license. IO did not say that. What did the IO say? IO, my lord, was very clear in his evidence where IO says he did not possess any valid driving license. I have asked him whether he has any driving license or not. He has answered he did not possess any license, my lord. So if this is the position of the evidence where IO has come and said there was no license, facts speak for themselves, my lord. Where is the question of us adducing any further evidence? Are we in a position to adduce any further evidence? Who do we call, my lord? Who do we call? Do we call the owner to say what, my lord? Because res ipsa loquitur, facts speak for themselves, my lord. Number one. The second judgment on the previous page, my friend for the claimant has relied on that. That is at para 63, my lord. The IFCO Tokyo General Insurance versus Geeta Devi judgment, yes, at para 63. My friend has read only the last 3 lines. As no such exercise was undertaken, the petitioner insurance company would have no right to recover the compensation, etc., etc., my lord. Now, the judgment has to be read in totality, my lord. As no such exercise was undertaken. What exercise? The answer, my lord, is 4 lines above. Presently, no evidence has been placed from there, my lord, if I'm allowed to read. Presently, no evidence has been placed on record whereby an inference could be drawn that the deceased vehicle owner ought to have gotten verified, my lord, this is important, verified Ujay Paul's driving license. Therefore, it was for the petitioner insurance company to prove willful breach on the part of the said vehicle owner. My lord, this is a case where the driver appears to have had some license. He had a license, and then the question was whether the insurance company could prove whether owner verified that license or not, my lord. This doesn't apply to our case, my lord. Ours is a case of no license, my lord. So this is in a different field, my lord. It operates in a different field. Our case, my lord, is situated in a different field, my lord. This is as far as the respondent number 1, the claimant, is concerned, my lord. Respondent number 3, that is the driver, has made 2 submissions. I'll quickly reply to those 2 submissions, my lord. Firstly, my lord, my friend for the driver has said that we cannot rely, my lord. What she has submitted is that, number 1, we cannot rely on the assumption of the IO, my lord. The assumption of the IO, my lord, it is not an assumption. It is a clear statement on record that has been unrebutted. Here, the fact of the matter is, driver has contested the matter before MACT. Owner has also contested. Driver has also contested. So therefore, if the owner has contested, what prevented the owner from taking the stand and stating whatever he needed to state as far as the driving license is concerned? And the most important question that Lordship will have to ask the respondents, especially number 2 and 3, is that did the driver step into the stand and say anything to the effect that I have a license? Nothing. So again, my lord, res ipsa loquitur, facts speak for themselves. So the United India versus Gyanchand judgment which I had read, the moment the owner did not step into the witness box, an adverse inference has to be drawn against him, my lord. So here, leaving aside everything, my lord, the fact of the matter is that driver was contesting the matter. If driver was contesting the matter, it was the duty of the driver to step into the witness box and say, yes, I have a license, or admit that I have no license. To put the burden on us, or to say, I did not summon the driver. Driver was contesting. Nothing stopped him from stepping into the witness box, my lord. Secondly, my lord, the counsel for driver has relied on the Rukmini judgment of 1998, which was again to the same effect, that since in that case, insurance company did not summon the driver, therefore we cannot, in that case, insurance company could not be released from liability. My response, my lord, is the same response, that I was not required to summon a party who was anyways contesting the matter, my lord. If that contesting party, the driver, had something to say on this issue of driving license, that party should have taken the stand, my lord. The silence of the driver, the silence of the owner in not adducing any evidence, my lord, I submit, speaks volumes by itself, my lord. So therefore, to say that it was my duty to summon somebody and it was my duty to prove, etc., my lord, 2018 Pappu versus the Pappu judgment of Supreme Court says very clearly, burden is first on the owner. That burden was not discharged. If owner had adduced some evidence, then the burden comes on us. We are not to adduce the primary evidence. If they have a license, they have to adduce evidence in that respect, my lord. So, my lord, we will obviously have to wait for the submissions of respondent number 2, as and when they make those submissions, and I will respond to those submissions also.
I'll just submit this judgment which I have relied, 2004, which they have relied, 2004 3 SCC. 2004 SCC, last paragraph 110. That is, yes, in that judgment also, my lord, in the last paragraph 110, that judgment, that same one which you relied, Swaran Singh, which in the last paragraph, my lord, 110, last paragraph, the provisions contained in subsection 4 with proviso thereafter and subsection 5, that is in the said judgment itself, to enable the insurance to recover the amount paid under the contract. So this judgment also, again, my lord, it is in my favor only.
Okay, this is
2004 paragraph, last paragraph, my lord, page number 342. To pay and recover. That's all.
when do we list the matter? When do we list the matter? What is this general counsel for the appellant? Also heard Akitomo, respondent 1 and respondent. Your respondent? 3. However, is the letter counsel for the respondent 2 has sought for accommodation on the ground that the letter conducting counsel is indisposed. Accordingly, matter is put up for the hearing on the next date. This is matter after 2 weeks.
Item number 4.
So this is that Assam rifle matter, Your Lordship, who is seeking similar benefits which was granted to the other personals. In fact, Your Lordship has also granted similar benefits to this same trade, Your Lordship. These are about 9 petitioners who are left out. They're seeking the same relief, Your Lordship. And these judgments are...
No, you have to leave this more to the facts and circumstances of this case.
Lordship.
The matter has not been heard.
It's not been heard, Lordship.
Wait, please. Lordship, learned senior DSGI is on legs before division bench, Lordship. Lordship, I humbly pray for some accommodation in this matter.
Lordship, I'm relying on Your Lordship's
Yes,
order.
Mr. She's seeking for accommodation.
It's basically as a covered matter, Your Lordship. Otherwise, I'll prepare a short note, Your Lordship.
Your cover, you see, your contingent will be it's a covered. They may say otherwise.
Lordship, I'll on the next day, Lordship, I'll prepare my advance notes as well, Lordship.
Whatever, you see, whatever. But you still have to,
Lordship,
advance
I'll
oral
advance
argument.
my arguments, Lordship. After a week, Lordship.
A week, Lordship.
Mr. Counsel for the respondent has sought for accommodation on behalf of the learned DSGI who is indisposed. Accordingly, Mr. ML appears for the petitioner. What he has prayed for, this is matter of 1 week.
Thank you, Lordship.
Obliged, Lordship.